Number 73. Counsel, you want any rebuttal time?
May I have 2 minutes, Your Honor?
2 minutes. Go ahead.
Thank you very much. My name is Michael Tantillo. I am the appointed special prosecutor in this matter. And this case essentially brings to the Court's attention the construction of the defense of claim of right found in Penal Law 155.15. And to my research, I believe that up until last year, that defense had never been construed in a reported decision in New York State in a case involving the appropriation of public property by a public servant. The only other case now is People v. Baruti, which actually emanated out of the same investigation as Zona, but it's completely different because that case dealt with abandoned property or allegedly abandoned property. I am essentially urging upon the Court 2 points. First of all, that as a general rule, generally speaking, a public servant can never have a good faith basis to believe that he can appropriate public property to his own private enrichment.
Well, how can you say you can never? I can understand you can never have a reasonable basis, but how can you say you can never have a good faith basis? And can't people in good faith believe almost anything?
In good faith, people can believe almost anything.
People believe in good faith. People believe in good faith that they've seen green men coming out of flying saucers.
That's correct.
And if they indeed, you know, there are times when that kind of good faith belief would be relevant and would give them a defense in a criminal case.
Well, in a good faith basis also requires some reason for arriving at that good faith basis. It doesn't. The law doesn't talk in terms of a belief, mistaken or not. It talks about a good faith basis, which therefore presumes that there is a basis for arriving at that determination. I think that's a distinction. A good faith basis is distinguishable from a incorrect or
Do you have any authority that says good faith basis has an objective element to it, that there must be some basis even for any good faith?
I don't, Your Honor, because I don't believe it's ever actually been construed. To my research, I haven't found anything that actually addressed that issue. I know that counsel makes that argument, but I don't believe that there is any authority for it at the present time for that proposition.
Mr. Tantillo, what was the you make the claim that there's no reasonable basis in the evidence for the judge to have given that charge.
Correct.
What was the evidence that you refer to that would eliminate that charge as something that ought to be given to the jury?
The only evidence that was adduced at this entire trial, which I call it 9 words, the defendant in a written statement to a police officer said, the undersheriff told us we could take whatever we want.
Was there evidence to the contrary that would indicate that would contradict that
yes,
statement? Yes,
there was.
What was that?
4 days later, in an interview with another state police officer, the defendant stated, you know, he really didn't tell me that. He somewhat implied that we could do that. And that subsequent statement was not challenged on cross-examination and not addressed on summation by defense counsel.
In the original statement, there are the 9 words that you mentioned, and there's also a few lines later in the same statement when he says in the following, you know, later on, Chris Constable told me that Jim Larson apparently did not have the authority to tell us we could take anything. Isn't it a fair reading of that Mr. Zona thought until Constable told him otherwise that Larson did have the authority?
I think it's a fair reading that that's what he said, but in light of all of the evidence in the trial, that's not a fair reading of what he thought.
But generally, if he'd said it on the stand, if the defendant takes the stand and says, I thought that was my wallet that I was taking out of the victim's pocket, isn't he, you know, I mean, the jury may not believe it, but doesn't he get the instruction that if the jury believes that, he should be acquitted?
Well, let me draw the Court's attention, turning to what I think is the case that controls this matter, People v. Watts, which is the case dealing with a justification defense, in which the defendant, again, didn't testify just like this case. He didn't testify. He gave a statement to the police in which he said, she came at me in my room with a knife. And this Court stated that that was not sufficient to draw the inference.
But wasn't the theory of that, even if true, even if she came at you with a knife, you haven't explained that you were justified in killing her?
Well, that's true, but just as the defense said in this case in Zona, the 2 dissenting judges said, just as in this case, the defendant then didn't go on in a statement and say, I believe, therefore, that I had the authority to take this property, or I believe, therefore, that the undersheriff had the authority to give it to me.
I understand your point, but if you read his statement as saying, in substance, I believe that I had the authority to take the property Isn't it for the jury to believe or disbelieve that?
I don't think we get to that point, Your Honor, because I think the court is required to listen to all of the evidence in this case. And every other shred of evidence in this case indicated that the defendant did not entertain that belief.
That's what I was hinting at earlier. Wasn't there evidence that he tried to hide the fact that he took the tires?
I wanted to get into that. That's exactly right. He, right off the bat, as soon as he took these tires, he traded them in for new tires for his own vehicle. Someone else comes up to him and says, wow, how could you afford those tires? Those are so expensive. I can't afford them. His response was not, well, the undersheriff told me I could take some other tires in return for this, so I traded him in. He said, yeah, the tire dealership gave me a great price on these because I helped solve some bad check cases for them. Now, if he truly had a reasonable, good faith basis to believe that he was entitled to those original tires, he wouldn't be making up phony stories. When he realized that this matter was the subject of an internal investigation, he never went to his superiors and said, the undersheriff told me I could take these. He went and bought similar tires at some store 30 miles away, and then late at night, under cover of darkness, without telling anybody, he went back into the warehouse, put them in there, and then took pains to cover them up with other property to make it look like they'd been there for a long time. This is evidence that is absolutely, utterly inconsistent with a belief that he was entitled, claims right defense to this property. And
the fact that there's a lot of evidence inconsistent with the defense doesn't mean the jury can't consider the defense.
No, I think the rationale in Watts and the rationale in Butts is that the court is required to parse the entire evidence, and if there is a reasonable view of the evidence that supports the charge, it should be given. But if on balance on all of the evidence being construed, there is no reasonable view of the evidence that would support the conclusion that he did this with justification, with claim of right, I mean, that it should not be given.
Counsel, what is our standard of review with respect to the appellate division decision?
Well, this was they decided this is a matter of law. And I think you have the right to say that their interpretation of the law based on your past precedent is incorrect. I cited a number of cases in which other courts have overturned judges' decisions declining to give the claim of right instruction. For example, Ricciuti, Brown, and Ace. But in every one of those cases, the courts, the appellate courts, took pains to note that not only did the defendant claim that he believed he had the right to take this property, but he produced corroborating witnesses to back up his claim.
Where do you think the appellate division went wrong in its analysis? I take it you think they didn't put enough weight on defendant's second statement?
I don't believe that they reviewed the entire record in total. The second statement, to my mind, is very compelling because he, without any contradiction whatsoever, basically admitted my first statement is false. But beyond that, he is telling false statement after false statement after false statement to every other person with whom he came into contact on this matter. He is engaging in furtive behavior in returning these things. He never once went to a superior. He never once told anybody that Larson had, the undersheriff, had given him this authority to do this. My belief is under Watts and under Butts, the case must be viewed in toto. And I think that the appellate division only took the one little sentence, 9 words, in the defendant's statement and said, aha, well, he said this, therefore we have to give the charge. And I think that's inconsistent with the understanding of what showing must be made before a defendant is entitled.
Would the case be different if he had testified and said under oath said the same words he said in his statement?
Well, I think it depends. Obviously, it would have been probed, clearly. I think that under certain circumstances, he may have been able to make out an entitlement to the defense, but he also may have even had less of a ground to argue for the defense depending on what he said or the cross-examination and so on. I think, again, that scenario would be case-specific, and it's just not presented here. The defendant in Watts did not testify. He just had his one-sentence statement, just as the defendant in this case had his one-sentence statement.
Anything else? Thank you.
If there are no other questions.
Okay. Thank you, counsel.
Scott Porter for Mr. Zona. Good
Yeah,
afternoon.
counsel, go ahead.
There are 3 issues for this Court to decide. The first is whether there can be any categorical exceptions to the claim of right defense. The second issue is what threshold of evidence should the Court consider before charging claim of right defense. And the third, of course, is whether the evidence in this case crosses that threshold. Briefly, to deal with the categorical exception argument, my client was deprived this defense at trial for a different categorical reason, that being he could not show a pre-existing legal interest. That rationale has disappeared while this case has winded its way up to this court, and now we have a new categorical exception proposed, that being a public officer can never take.
Well, except that where you didn't previously own the property, when you haven't paid for the property, don't you need to do something more than just say, I thought it was mine?
Yes, and that leads to the second.
What
the threshold,
my next question
yes.
to you is,
Yes.
what's the plus that we have here that would entitle your client to the defense?
There are ample facts, and the legal standard I think the court should require when a defendant is asking for a claim of right jury charge is whether the surrounding circumstances support the good faith claim, or did the defendant act pursuant to that subjective belief. And by using that standard, you can look at the context, because I am not proposing that it is permissible for a defendant to say in a very self-serving way, oh, I thought I could do this, I thought I had permission, and get the charge based on that naked statement alone. No, because that's conclusory, that's self-serving.
What about somebody told me I could take that?
Well, then we...
That alone is enough?
No, I don't think it is. We need to see who this person was who gave
That's what we have here.
Right,
So
and
what
who
we
is
have
this
here, his
person?
statements, he told us we could take what we want.
And the person who said that is his direct supervisor.
And you would say that the statement should be interpreted, although Zona didn't quite say it, as, and I thought he had authority to say that.
Circumstantially, it is reasonable to infer that my client believed that his boss, the undersheriff, had the authority to tell him that he could take the property.
And what about his subsequent statements where he seemed to move off that posture?
Two answers. One is that it is a general principle that we review the evidence in the light most favorable to the defense. We have a written statement, we have an oral statement. My client is entitled to have the written statement construed in the light most favorable to him. To use another statement that is in more favor of the prosecution's position is not viewing that evidence.
No,
We
that's...
also have other conduct, too, that seemed to be inconsistent, his returning the tires.
Right, and I think we have two competing versions of guilt or innocence. And I can make the case that there is a colorable claim of right, and my adversary can make the case that there is a colorable claim of guilt.
If he said, either in his statement or his testimony, if he said in substance something on its face presumably not ridiculous, he said, I believed I've been given permission by someone of authority to take these tires. And if you persuaded us that that actually happened, is it completely irrelevant that there's a ton of evidence showing that's false?
No, because, as I said earlier, the court has to go beyond the naked statement, the utterance. And it is fair for the court to look at whether that statement is so specious that the defendant should not have the benefit of the claim of right.
Looks pretty specious here, doesn't it? If he's, the next morning he's going around telling people he inherited the tires from his rich uncle or whatever he told them.
Well, I think there's a distinction to be made here when we look at the post-taking conduct, because what the key determination is what my client's state of mind was at the time of the taking. It's not
So
what he did after.
He
It's
could have been in
relevant.
good faith when he took the tires and then the next morning realized he wasn't supposed to take them and started to lie about it.
There's a distinction between intent to steal and consciousness of impropriety. And to extrapolate the post-taking conduct and to bar this defense as a factual matter would ignore the evidence that's in this record that supports the claim of right.
But there isn't, the point is there isn't any evidence. I mean, he said what he said, and you're right. Okay, this is what he said, therefore he's entitled to a charge, except 1, 2, 3, 4, and 5 contradict 1. And there is no reasonable view of the evidence under which this jury could logically conclude that he had a right to take these tires. and therefore I'm not giving the charge. And I'm sorry.
I respectfully disagree with that premise, because I think there is significant evidence, certainly reasonable evidence, to give rise to the claim of right. And it is simply not being told that you have permission to take the property. Also relevant are these factors. My client could have taken this property at any time. He didn't. He took it when his boss told him.
Yeah, but if I take your car this afternoon, it's not a defense that I could have taken it last weekend.
No, but we're talking about the honesty of his belief. And when he was told that by Deputy Constable that he did not have authority, the undersheriff, he returned the property. Also important is the nature of the property. What are we talking about here? We're talking about a boat with bullet holes, a cabinet of some sort, and these 5 tires. Now, because these tires have stickers on them, I understand that from a quality standpoint, it raises a concern. But these tires are being kept in a surplus warehouse that stores a lot of junk. And these deputy sheriffs, along with the undersheriff, are moving this surplus property, mostly junk, from one warehouse to another. They're using their private vehicles. The sheriff himself, undersheriff, is taking an old light, old lawnmower, a canoe. The other deputy sheriffs are taking a canoe. And this is the context at the time of the taking in which he is being told you can take what you want. And he takes these 3 items. He returns them when he's told that the undersheriff doesn't have authority to return those items.
Is there testimony to all those facts presented as part of the defense case?
Investigator Deal testifies to a great deal of the facts that I just recounted. The rest come from my client's written statement. And that is the scenario in which this property came in. That's the scenario in which my client took
Who owned the property, the county or the sheriff's department?
We don't know. I don't think one can read this record and state with any certainty whose property it is. The mystery of the property is the origins of the property is a mystery. The Seneca County Sheriff's Department was keeping its tire inventory at another place, and the record.
Somebody asked for an investigation, correct?
Right, and that was after the taking, and that gives rise to my client's consciousness of impropriety. He knew that he was in hot water with the department, but that doesn't mean ipso facto that he stole the tires at the time that he took them in the warehouse. Those are 2 different considerations at play here. And claim of right is an honest belief. It can be mistaken and it can be unreasonable. And my adversary cites Watts for precedence with respect to this Court's review of the evidence. But Watts is a justification defense, ordinary like this defense, but it has an objective reasonableness requirement prong to it. Claim of right does not. It is subjective. It can be unreasonable. What matters is honesty. And the defense that I think
does that, all I can think of while you were talking is someone, steals a farmer's cow, and he says, I swear to God, thought it was my cow. And so there's no way it was your cow. You don't own a barn, you don't own a farm, but at the time, I thought it was my cow. And it's the most ridiculous thing somebody can say. But you would say, you gotta give it to the jury.
Well, if the evidence shows the person acting on that subjective belief or the surrounding facts are consistent with the belief, if the belief is honestly held, yes. And that's the other defense I was going to mention is mistake of fact. That is most analogous to claim of right because there we have a subjective reasonableness requirement. And in those cases, the couple of appellate division decisions that have not allowed the mistake of fact defense to be charged state that all we have are conclusory statements by the defendant. I go back to the facts I delineated earlier. My client at the time of the taking arguably had a good faith belief, an honest belief that he could take this junk, these surplus items with him at the time that they were moving the property. And because he returned them when he was informed that the undersheriff did not have authority, that shows that he acted consistent with that belief. And I understand that there's other evidence in this record, but my client is entitled to have the evidence viewed in the light most favorable to him. And that's what we're asking for here.
But that does not mean ignoring evidence, right? So when, as Mr. Tantillo points out, he tries to hide the fact that he's returning the tires. We don't ignore that. I mean,
No, but I would ask the court to keep in mind that that's relevant also to the consciousness of impropriety vis-a-vis the department. It's not evidence, or rather it's not proof that he had the intent to steal at the time he took it. It's a fact that if you're going to weigh it, that is not as probative as the facts as they existed at the time of the taking. It is secondary to the facts that I mentioned earlier, what was going on at the time my client took possession of those 3 items.
Okay, Counsel.
Thank you.
Counsel rebuttal?
Just very briefly, Your Honor. My adversary posits to this court that his client had a good faith basis to believe he had a right to take that property, but he has not articulated any reason why he entertained that basis. As I indicated before, all of the evidence that was produced to the jury.
What about the interviewer who testified on the stand? At the time he was telling me this, I didn't know whether he'd done anything wrong. Doesn't that suggest that it's possible for a layman to, especially a layman whose judgment is colored by his own self-interest, say, oh, this is okay, my boss is telling me to do it, it can't be wrong?
Judge, I think that was further explained by the witness. You have to understand the context in which this investigation began. This investigation began because of an arson, or alleged arson, in which that warehouse went up in flames and was a complete loss. The New York State Police was called in to investigate that. That's what they were initially looking into. As they were investigating that, this other stuff, not just this case, but other cases about misappropriation of property came forward.
But all I'm suggesting is whatever the circumstances are, it's possible, even for a neutral observer, to get a little confused about what's right and wrong here. Well, for sure, wasn't it possible for the guy who's getting the tires to kid himself and say it's perfectly fine for me to take these tires?
With all due respect, Judge, I would take the position that it's not possible to be reasonably confused about this. I think we, going back to my initial point, head down a very dangerous slope if we can say that a police officer can entertain a reasonable belief that he can help himself to public property.
No, it doesn't have to be reasonable. No one's saying reasonable.
That he can have any belief that he can appropriate the county's property, convert it to his own benefit, and enrich himself as a result of that. And
so you're saying even if he had sworn up and down that he thought he could do it, and there was no contrary evidence, he still doesn't get the charge?
No, I'm not saying that. I'm saying that there was a wealth of contrary evidence.
I understand you say that, but you're saying that's not necessary. You're saying he has to have a basis for his belief, or that's the end of the discussion.
Your Honor, if he had gone to the first person and said, you know, that Larson, that undersheriff's a great guy. He told me I could take these tires, and as a reward for helping move this stuff, then you've got objective evidence that would indicate that he honestly believed that. But all of the statements that he made to every single person in this case was exactly the opposite.
That's really in contradiction, isn't it, to your theory that no public servant can ever believe that he's entitled to do that?
I'm arguing both theories, that it's a hard sell to believe that any public servant could ever do that, but even if you want to look at the particular facts in this case, that defense has not been borne out.
Okay. Thanks, Counsel. Thank you both.